Hi, I'm Ankita Sangwan, Research Associate in National University, Delhi. Today's topic of discussion is registration, incorporation, and commencement of business by companies. Once you have determined to start your business and you are ready to set up your business, few common questions which come to your mind are: what is the type of business organization in which you want to run your business? What do you need to do for forming your company? And how to proceed and from where you should start your business? To guide the students through this process, the following module will help in answering the above questions. One of the first steps is to register your proposed company with the Registrar of Companies of the state in which you are establishing your business. In India, the incorporation of a company is governed by the Companies Act 2013. It is the most important piece of legislation that empowers the central government to regulate the formation, financing, functioning and winding up of companies. It applies to whole of India and to all type of companies, whether they registered under the Act or any earlier Act. But it does not apply to universities, cooperative societies, unincorporated trading, scientific and other societies. The present module will give you an overview on registration and incorporation of companies. The learning objectives of the module are: students shall be able to understand what is meant by registration and incorporation of company. They shall get to know what is the process of registration and incorporation of a company, and the documents which are required to be prepared by the companies for their incorporation. They shall also be able to understand the advantages which are accrued after the corporation of a company. The Companies Act 2013 stipulates the process of registration and incorporation of companies in India for all types of companies, including private and public companies. Minimum 2 directors and 2 shareholders are required for incorporating a private company, whereas minimum 3 directors and 7 shareholders are required for incorporating a public company. Minimum paid up share capital of a private company at the time of incorporation should be 1 lakh rupees, and it should be rupees 5 lakhs for a public company. Companies which are set up with the foreign investment have to be incorporated under the Companies Act 2013 with the Registrar of the Companies. Once a company is registered in India, it is guided by the Indian laws. A company is formed by registering the Memorandum and Articles of Association with the Registrar of Companies of the state in which the office of the company is to be located. Now we'll discuss about the registration of companies. Doing business in a company form of organization gives its promoters all the advantages of a corporate personality, which includes separate corporate existence. Besides this, the promoters get many advantages, for instance, tax benefits, safeguarding the name of the business, and many more. Another benefit of registration is receiving some legal liability protection. If you incorporate a company, you will not be held personally liable for certain accidents and liabilities. Consequently, you may find it easier to obtain business insurance or attract investors, since they will know you are not personally responsible for the company's well-being. Following the above reasons, registration of a company is an important part of starting a business. Therefore, before registering a company, one needs to fulfill some legal formalities for which promoters must make a decision regarding the type of company they want to start. That is a public company or a private company or limited or unlimited company, and accordingly prepare documents for incorporation of company. In this connection, the Memorandum and Articles of Association, now known as Memorandum and Articles respectively in the Act of 2013, are fundamental documents to be prepared. Now, formation of a company. Section 3 of Companies Act 2013 lays down the process of forming a company. The section states that a company can be formed for any lawful purpose by 7 or more persons in case of public company and 2 or more persons in case of private company, and by 1 person in the case of 1 person company, which is regarded as a private company by the 2013 Act. They can do that by subscribing their names to a memorandum and complying with the requirements of the Act of 2013 in respect of registration. Section also states that the companies formed under subsection 1 may be either a company limited by shares or a company limited by guarantee or an unlimited company, provided that the memorandum of 1 person company shall indicate the name of the other person with his prior consent for the same and for the purpose of becoming a member of the company in the event of the subscriber's death or his incapacity to contract. It is also laid down in the Act that a written consent should be filed with the registrar at the time of incorporation of the 1 person company, along with it a memorandum and articles by the said other person nominated should be filed. It is further provided by the Act that if such other persons wants to withdraw his consent, he can do the same in the prescribed manner only. In case of 1 person company, if some changes are brought in regards of change in the name of the person or any other change, then the company shall intimate this to the registrar in the manner prescribed. Now we will talk about the Memorandum and Articles of Association of a company. For the purpose of incorporation, Memorandum and Articles are the most important documents to be submitted to the ROC, that is the registrar of the company. The memorandum is a document that sets out the foundation of the company. It contains the objectives and the scope of the activity of a company, as well also defines the relationship of a company with the outside world. Whereas articles contain the rules and regulations of the company for the management of its internal affairs. Objectives and purposes for which the company has been formed are contained in Memorandum of Association, and the rules and the regulation for achieving those objectives of the company are laid down in the Articles of Association of a company. After the required documents have been presented to the ROC along with the required registration fees, he will give the certificate of incorporation to the company if all the formalities are complied with. Now we will talk about the certificate of incorporation. After the duly stamped memorandum and articles, documents and forms are filed and the filing fees are paid to the ROC. Then the ROC examines the documents and if required instructs the authorized persons to make necessary corrections. Thereafter, a certificate of incorporation is issued by the registrar of the company, which brings the company into existence. It also is the conclusive evidence that all the requirements of this Act have been complied with in respect of registration and matters precedent and incidental thereto, and the company is authorized to be registered under the Act. It takes 1 to 2 weeks from the date of filing Memorandum and Articles to receive a certificate of incorporation. In the case of Musa Ghulam Arif versus Ibrahim Ghulam Arif, it was held by the court that the certificate of incorporation is a conclusive evidence for all purposes. Now we will talk about the pre-incorporation contracts. Sometimes contracts are made on behalf of a company even before it is duly incorporated. But no contract can bind a company before it becomes capable of contracting by incorporation. Two consenting parties are necessary to a contract, whereas the company before incorporation is a non-entity, and this was held in the case of Kellner versus Baxter. A company has no status prior to incorporation. It can have no income before incorporation for tax purposes. Shares cannot be acquired in the name of the company before incorporation, and the transfer form is liable to be rejected where the name of a proposed company is entered in the column of a transferee before incorporation of a company is concerned and done. And this was held in the case of English and Colonial Procedure Company. In order to get the benefits of a corporate personality, it is very necessary for an association of persons to become incorporated under the Companies Act. It would be a matter of inconvenience that an association of persons cannot perform any official business operation in the name of company before it's incorporated. Therefore, promoters of a company may enter into the agreement for the benefit of the association of person or prospective company, and these agreements are known as pre-incorporation contracts. One might question that why is company not liable even if it is beneficiary to contract, or might also question that doesn't promoter work under principal agent relationship? Answer to such questions is simple. The company is not in legal existence at time of pre-incorporation contracts. A person not in legal existence cannot be a party to a contract, as we all know. And the privity to contract doctrine excludes company from this liability. And this was held in the case of Kellner versus Baxter and Phonogram Limited versus Lane case. This position was confirmed. In pure common law sense, pre-incorporation contracts does not bind the company. But there are certain exceptions to this contract, and these exceptions were developed in USA, India, and later in England. These exceptions are: first, under the Specific Relief Act 1963, Section 15H and Section 19E are the two important sections for pre-incorporation contract. Section 15 is about stranger's right to sue if he is entitled to a benefit or has any interest under the contract, although it has certain limitations. Section 15H talks about the company being a stranger to pre-incorporation contract has the right to sue to the other contracting party, but the necessary condition is that the contract should be warranted by the terms of its incorporation. This provision clearly negates the common law doctrine which says that the company cannot ratify or adopt the pre-incorporation contract. Under this provision, promoters can give his right to sue to the company, whereas the relevant portion of section 19 subclause E states that except as otherwise provided by this chapter, specific performance of a contract may be enforced against. When promoters of a company have before its incorporation entered into a contract warranted by the terms of the incorporation, provided that the company has accepted the contract and communicated such acceptance to the other party to the contract. This position was accepted in the case of Vali Patabhibram Rao versus Sri Ramanuja Ginning and Rice Factory Private Limited. The second exception is novation of contract. What do we mean by novation of contract? In the situation of novation of a contract, the company can replace the promoter from the pre-incorporation contract. But one might say that such contract would not be called pre-incorporation contract, but it should be called post-incorporation contract, because novation of contract result into a new contract. This position of novation of contract was accepted in the case of Howard versus Patent Ivory Manufacturing Company. Now we'll talk about the incorporation of company under the Companies Act 2013. Under the Companies Act 1956, for incorporation, all the important documents are filed with the registrar of the company, whereas under 2013, Section 7 talks about the incorporation of a company, and it states that the documents shall be filed by the company to the registrar within whose jurisdiction the registered office of a company is proposed to be situated. Subsection 1 of Section 7 lays down the list of following documents and information which is required to be filed by the company for incorporation. First, duly signed memorandum and articles of the company by the subscribers of the memorandum in the manner prescribed should be submitted. Secondly, a declaration in the prescribed form by an advocate, a chartered accountant, a company secretary, a person named in the articles as a director, manager or secretary of the company that all the requirements have been complied with. Thirdly, an affidavit from each of the subscriber to the memorandum that he is not convicted of any fraud or offence in connection with the promotion, formation or management of the company. The particulars of name, surname, residential address, nationality of every subscriber to the memorandum with an identity proof, and in case of subscriber being a body corporate, such particulars may be prescribed. The particulars of the person mentioned in the articles as first directors of the company should also be filed. On the basis of these documents and information filed under the subsection 1, the registrar shall issue a certificate of incorporation in the prescribed form. To this effect, the proposed company is incorporated under the Act. Subsection 3 of Section 7 of this Act states that on and from the date mentioned in the certificate of incorporation, the registrar shall allow to the company a corporate identity number, which will provide a distinct identity to the company and will also be mentioned in the certificate. Under the present Act of 2013, the company shall also maintain and preserve at its registered office all the documents and information filed, and if any person furnishes any false information, he shall be liable under Section 477 of the given Act. Regarding the above penal action, a tribunal may pass an order as it may think fit for regulation of the management of the company, or may direct to remove the name of the company from the register of the companies on being satisfied. After the certificate of incorporation issued, the registrar shall allot the company a corporate identity number, as we have already discussed, provided that before passing any order in regard, the tribunal should give a company a reasonable opportunity of being heard, and the tribunal shall take into consideration the transaction entered by the company, including the obligations, if any, contracted, or payment of any liability. Now we will talk about the commencement of business. Under the Companies Act 1956, a private company had the right to commence its business right from the date of its incorporation. However, in the case of a public company, a certificate of commencement of business had to be obtained. For this purpose, the following additional formalities had to be complied with. Section 149, subclause 7 of the Companies Act 1956. If a company had share capital and had issued a prospectus, then first, shares up to the amount of minimum subscription must be allotted. Secondly, every director must have paid to the company on each of the shares which he has taken the same amount as the public have paid on such shares. Thirdly, no money is or may become payable to the applicants of shares or debentures for failure to apply for or to obtain permission to deal in those shares or debentures in any recognized stock exchange. Fourthly, a statutory declaration in Form 19 signed by one director or the employee, company secretary or a company secretary in whole-time practice that the above provisions have been complied must be filed. And if a company had share capital but did not issue a prospectus, then what happens in this case? First, it must file a statement in lieu of prospectus with the registrar of the companies. Every director must have paid to the company on each of the shares which he has taken the same amount as the other members have paid on such shares. Thirdly, a statutory declaration in Form 20 by one director or the employee, a company secretary or a company secretary in whole-time practice that the above provisions have been complied with must be filed. Once the above provisions have been complied with, the registrar of the company grants certificate of commencement of business, after which the company can commence its activities. Under the Companies Act 2013, a company having a share capital is not entitled to commence its business or exercise borrowings powers unless, firstly, a declaration is filed by the director of the company with the registrar of the companies that every subscriber to the memorandum has paid the value of the shares agreed to have been taken by him, and the paid up share capital of the company is rupees 5 lakhs in case of a public company and 1 lakh in the case of the private company. Secondly, the company has filed with the registrar of the companies a verification of its registered office. In case no declaration is filed by a director of the company within 180 days of the incorporation of the company, the ROC has reasonable belief that the company is not carrying on any business or is not in operation, and he may initiate action for removal of company's name from the register of the companies. Now, let's look at the procedure for formation of a company in India. What are the different steps a person has to follow to form its company under Indian law? The first step is to obtain director's identification number for the proposed directors of the company. The second step is to obtain digital signature certificate for at least one director for the purpose of filing the formal for filing the forms electronically. Third step is to file an application for the approval of the name of the company. Fourth step is preparing the Memorandum of Association and Articles of Association of the company, which are very important document. Fifth step is to have the appropriate number of persons to subscribe to the Memorandum of the company. Minimum 2 in the case of private company and minimum 7 in the case of public company, as we have already discussed it. Sixth step is to submit all the documents along with the required fees to the registrar of the company. Seventh step is registrar of the company should issue a receipt of certificate of incorporation after all these documents are filed by the company in prescribed manner. Then the eighth step is, in case of a public company, obtain a certificate of commencement of business from ROC. Finally, after doing all these formalities, a company come into existence and you can start your business.